have clients that have a trust and they still want to give several assets to their adult children. It's a common thing. They own a home and they don't want to put the home into a trust. They want to give it to one of their children. They want to give them a monetary gift. They want to give them access to their bank account. Sure, if that's a reasoned decision, and you've taken a look at the totality of the circumstances, then sure, do it. But if you give your child the house, say that the property that you live in, there could be problems. Are you giving your child a large capital gain tax consequence when they ultimately sell it? Well, you're giving it to them at the present day value. You give it to them at the basis, right? So if the house is $1 million present day, but you bought the house for 250,000, well, you're giving that to them now. And are you giving it to them at 250,000? Are you giving them that asset at zero because it's a no consideration transfer? And when they sell, will it be capital gains from the beginning amount all the way to the then the sale amount? If you had given that asset to them inside of a trust, the mechanics of a trust are that it preserves the stepped up basis. So that might be really what about a different consideration? You give it to a child now and that child gets divorced. Is that now part of their marital estate? Has it been somehow commingled or transmuted? And did it go from a separate property? Inheritance is separate property unless you take some affirmative action to commingle it. Well, if your child has it during their marriage and they get divorced, have you or they unintentionally commingled that asset? Whereas if you transferred it into a trust and held it in trust for your child, it would protect them in these two instances that I mentioned. It gives them the stepped up basis at some future point in time upon your passing, and it protects them from potential inevitable, but a potential divorce. So think about how you give an asset to your children. Think about it. It should be part of your estate plan.